Regular meeting, Building Board of Appeals for the City of Ann Arbor, Thursday, November 15th, 2018. Have a roll call, please.
Yes, we can. We'll start with staff. Glenn Dempsey. Here. Ryan Miller.
Here.
Kathleen Summersgill.
Here.
Kristen Larkham.
Here.
Deborah Williams.
Here.
And Zach Wass Smith. I am here. Board members Paul Darling.
Here.
Robert Hart.
Here.
Ken Winters.
Here.
Gordon Berry.
Here.
David Arnsdorf.
Here.
And Hugh Flack.
Absent.
Absent. Excellent. We have a quorum.
Thank you. First on the agenda is approval of the previous meeting. First on the agenda is approval of the agenda. If we can have motion, did everybody receive the agenda? Any questions on that?
No.
Have a motion for approval?
I move to approve. Second.
Can we have names, please?
Approval was David
Yeah.
and Paul, second.
Thank you.
Motion and approval, all those in favor?
Aye.
Approved. Approval of minutes for what was the last meeting in May of 2018. Everybody received that in the email from staff?
Yes.
Any questions or comments on that? If not, we could have a motion for approval.
Move to approve the minutes?
Second.
Motion by Bob Hart. And approval,
David.
I think David.
Second.
David Armsdorf. And the motion and approval, motion and second, is there a vote for approval? All those in favor?
Aye.
Opposed? The minutes for May have been approved. And next we go on to appeals, actions, and show cause hearings. First on the agenda is BBA 18-006 at 1625 Waltham in Ann Arbor. If staff could give us.
I need to make a disclosure before we start the staff report. So about 10 years ago, I had a liner system installed in my house, personal residence, by Rooter MD. But I don't have any financial interest in this particular appeal or knowledge about this appeal besides that. And I want to disclose that.
Okay. So just disclosure. All right, thank you, Paul. And if staff can give us a summary of this appeal?
Yes, Glenn Dempsey. The appeal was submitted to the building department from the applicant Oscar Rodriguez to asking for desired relief in regards to the address of 1625 Waltham Drive. And the relief, they're asking that a finding that the SOP 501 applies to this permit, that a finding that there is no violation of the MRCP 3005.3, and they have various attachments involved. This was to find an appeal basis that the violation from Ryan Miller on an inspection based on a video that was provided, that it was not sufficient and adequate for the intention of the code. The basis of the appeal is the proper SOP has no evidence that there is in fact non-compliance with P3005.3, which is the Michigan plumbing or the residential plumbing code. And there's various attachments and discussion that takes place in the submittal that's been provided. In fact, I guess as the building official's final response and conclusion is that we would ask that the board deny this approval based on the intent of the code not being met, and that again was 3005.3. This is a CIPP liner. It is a liner that is put in place to help the drainage of a sewer line from the house to the main sewer.
Okay,
So-
thank you. Is there someone here in the audience to address this, let us know about the appeal?
Yes, thank you. My name is Oscar Rodriguez, and I represent Mr. Wood and his company.
One quick thing, have you signed in?
No, I have not, but I will sign in now.
Thank you.
Before we get started, you know, I don't do these types of appeals very often, and so if you need to correct me on the procedure or the timing, please just let me know. My intention here is to present our appeal and the issues as we see them and have ourselves be heard. I'm not sure if there's a time limit, and I'm not suggesting that I'm going to be here for hours or anything like that. But it would be good to know if there is one ahead of time.
There's no time limit, but I will ask that you limit your discussion to the three items that are being asked for the appeal.
Certainly. With respect to the three items, however, we frame the issues a little bit differently in our appeal, and I trust that everyone has had an opportunity to look at the appeal package that we submitted. And I don't want to repeat verbatim, but I think that it's important. There are some videos that I alluded to in the appeal that we obviously can't just show on the printed appeal. So let me just get started. The issue for us is simply my client, who's been doing these CIPP liners for many years, almost since 2002 at least, with this kind of product. Been a master plumber for many years and been in the plumbing business for 45 years. Comes into Ann Arbor and installs, I think by our count, is about 50 of these liners. And as Mr. Dempsey pointed out, essentially you line an old sewer line that's in disrepair. Orangeburg is very popular in this area, and so it's a very common thing to see this type of liner. The reason it's different from what we normally think of open trench replacement of a line is because the idea is that it's trenchless. So you go in without digging up a yard and you line. That's what the product is, that's what the technology. It's not that complicated. It's a liner that I have an example of that kind of cures like this. And this is not exactly what was at issue at Waltham, but the idea is that it just cures, molds inside the line that is broken. That's what he does. He's been doing this for a long time. This particular case was 2014, and this was at Waltham. In your report, you saw, and I think it's important anecdotally, you saw a affidavit from Ms. Brooks, the owner of the home, that explained to us in this affidavit is recent, that she's, since the completion of the work in 2014, no further work has been required and there have been no problems. She also writes, I am 100% satisfied with the work completed by Reuter MD. I'm just trying to set up that this is, practically speaking, this is what we're dealing with. a satisfied homeowner that is still covered by the 10-year, now 12-year warranty that was offered by Reuter MD. So this is one of 8 cases. It used to be one of 32 cases because prior to October of 2017, the issue before with the city was whether or not this product was even acceptable, okay? And this was the MLK product. The MLK product, and I think you heard from Mr. Wood last year on an appeal on that product. As it turns out, the board found that the product's not specifically named. There was no certificate of acceptability at the time, so denied. We're not here on anything like that. The certificate of acceptability was approved October 11th of 2017. October 30th of 2017, Mr. Ryan Miller went to 8 homes that Mr. Wood had installed these liners on and inspected videos related to, including Waltham, and said that there's a violation of this P3005-3. P3005-3 is a slope requirement, and it says that for lines of diameters of 3 or more inches, there needs to be a slope of 1%. That is what the March letter that is attached to the packet provides as the basis for this violation. Violation of P3005-3. So that's what we're here about. We have filed this appeal on 3 bases, okay? The appeal is based on that the city in the past has approved other trenchless processes with this, and I'm gonna use in air quotes, similar water issue, without issue, okay? They've approved them. So to us, now we're not applying the true intent of the code. The true intent of the code from the city's perspective was that this was okay, and now it's not okay. That's one basis, okay? The second basis for it is that 3005-3 does not apply. And where we get support for that is that there's an SOP from 2016 that we'll get into that clearly provides what the rules are gonna be for CIPP installations, okay? And the rules are that certain humps, bellies, intrusions are acceptable. That SOP has been used by the city, not provided to us. We found it by happenstance over the summer on eTrack It. That was not produced. 3005 doesn't apply according to the city's own policy, okay? Because it was not applied in that particular case, and presumably it applied to other cases as well. And then the last component of why there's no violation of P3005-3 is that there is no evidence there's actually violation of the 1%. In order to get a conclusion that 1% slope wasn't met, there needs to be, by definition, a calculation. What happened here, I don't think there's any dispute, is that Mr. Miller eyes the video and says, slope not met, 1% not met. Our problem with that is that that's not how it was done with other videos. And I think that from a due process standpoint, it's purely unfair to Mr. Wood. I mentioned some videos in the appeal with respect to the first component of our argument, and that is what the city has done before. I have those videos today, and again, these videos aren't very long, but I'd like to show what the city has done in other trenchless, meaning, well, you know what the concept is here, what the city has done in other particular cases. The first video we're looking at here, which hopefully pulls up, is by one of Mr. Wood's competitors, Roto-Rooter, and it's a...
Excuse me, I don't think that it's relevant what is been done before on a different project by a different contractor.
Can I explain to you why, maybe an analogy, if law enforcement takes a certain position over and over and over again with respect to something, the people start relying on it. Then law enforcement says, for this particular case, we're gonna look at it differently. That's why.
Can you show us the video that was done by Mr. Miller on this case?
Yeah, I'm planning, that's the.
Now.
You are 4 videos.
This video does not,
So I will not, I'm not here to argue with anyone. If you're telling me that I should not show these videos, I will not show the videos. There's a procedure. I'm just saying that the whole point of the code is to apply, the intent of the code is to make sure that we don't have danger to human life, okay? And the building official is charged with that responsibility. I'm looking at what the building officials have done in this very city for years to show what they think the true intent of the code is. If you're telling me not to show it, I don't have to.
just a moment. Anyone on the board want to see the video that is not relevant to this case?
It seems to me that the only real question here is the 1% is clear in the code, that you want
Aren't
that.
there other percentages in the code?
I think it varies depending on the pipe size.
Depending on the
Pipe
pipe size,
diameter.
yeah. But, I mean, you basically want a little bit of slope and not too much slope is the basic rule in sewer pipes. So the only question here is there clear evidence that there isn't slope in this one? And if so, why? What is it, and how good is that evidence? I don't know what else to say about this.
So that says that
I don't-
the only video that we need to see would be the one of this case,
Yeah,
correct?
and I don't see how this, I mean, we can't really rule on due process law anyway, so we have no, I don't know, all we're really ruling on is code, I think.
Right. Any other comments by the board?
No, I agree. I mean, I take it a step further that, I mean, I just happened to see the video of the house in question. So I don't want to short-circuit your presentation, but to me, this is strictly a chronology issue. The permit was pulled in 2014. It was a particular code in effect, which was 3005. For whatever reason, so the city then issued this SOP, which may or may not be relevant, but the inspection didn't occur until 3 years later. But it should still be based on the 3005.3 because that was the code that was in effect at the time the permit was pulled. Has nothing to do with precedent or anything else.
Can I address that point specifically?
Sure.
The Trinity Lutheran Church that had a CIPP case, that case, the SOP came after that work was done. So they created an SOP for purposes of approving this church product, this church installation. So on your chronology issue, that's my problem with it is, you're saying it happened before, so the code applied. The P3005 applied, and SOP 501 doesn't. Well, then that should have been the case with the church. But I get what you're saying.
But we're not here to judge on the inconsistencies of application that the city may or may not have. I mean, I have plenty of questions about the SOP and chronologies on other projects. This has just to do with this particular project and the inspection that was made and the challenge that was made as to whether proper slope was applied.
Certainly, and I
it's-
respect
and-
what
and-
your
and it's
position
ba-
is.
And it's based, and I think correctly so, on the fact that the 3005 was in effect at the time that the permit was pulled. The SOP 501 notwithstanding is actually irrelevant to this, again, in my opinion, but
And is
but-
there a basis for that, or just your opinion?
it's my opinion that the 3005 is the one that's in effect, was the code provision that was in effect at the time the permit was pulled. I mean, I'll tell you, I'm an architect. We have had plenty of projects that have transpired over a change in code. If we get our project permitted and approved under, an older code, that's the code that's in effect. It's not what happens 2 years later when the project is finished and inspected. You don't apply the inspections and the criteria of the code to the times. It's retroactive to when the permit was pulled. And what?
Mr. Hart, I respectfully, you just used an anecdote from another part of the world and the way things work to explain. That's exactly what I'm trying to do with the city's
No,
mindset
but it isn't.
on this
It's
issue.
not, it's not.
And now we're gonna ignore it.
No, then maybe I didn't make myself clear. So let me just go back to my take on this from a chronological point of view. The permit was pulled in 2014. P3005.3 was the code that was in effect at the time, so that when the inspection was done 3 years later, the code that was still in effect at the time should be the 3005.3.
Does
Again,
that apply to Trinity, or it doesn't apply to Trinity?
Trinity, that's, what the city did on another project is not material to this. That's not the issue. You can't go back and rewrite or look at all the wrongs or rights that might have been done over the last, dozen years. Because that's not what the case is about what this is about.
Okay.
Again, in my opinion, but I don't want to hang up the
Yeah,
whole hearing
that's
on
okay.
this.
I want to
So-
address these points. I mean, you know that the SOP is permitted by the code itself. It says that the building official shall have the authority to render interpretations of this code and to adopt policies and procedures in order to clarify the application of its provisions. This is R104.1. That's exactly what Mr. Strong did. And I asked Mr. Strong to participate in this process. He initially did, and now, for whatever reason, he's not participating in this process. And I think it's fully relevant, and I will move on. I understand that you disagree with me, that the city can decide how to apply the true intent of the code by their interpretation, and that's what they did. They were doing it both officially through SOP 501 and unofficially by the way in which they approved videos that I'm not going to show, but that are certainly within the record. So going, I guess, to your and with respect to the 3-year delay on the inspection, the videos of the process of the approved for Waltham, for example, were given to the city right away by DVD. They were given to the care of Mr. Ratliff, okay? Mr. Ratliff is not here today, and we're not allowed to subpoena folks and ask them questions, et cetera. I understand. For whatever reason, and partially at my client's fault, he doesn't follow up on those videos. But Mr. Ratliff has them. And that's, I'm just explaining to you that the city was not that interested in getting this done. But I understand that Mr. Wood, in retrospect, should have said, hey, Mr. Ratliff, what about my videos? But that's why we had a 3-year delay. Meanwhile, of course, we have a happy customer. But if you want me to narrow it to the issue of whether strict application of P3005.3 means that there's a violation here, I think that it's very clear that, and I'm going to give you the example of a riser, the riser, stair riser rule. I'm just pulling this out right now. I know that there's a rule that says that stairs, the risers may be not a minimum of 4 inches or something, not a maximum of 9 inches. There are specific numbers that are put in that regulation, and I've seen it, I think, in the city's website. It's certainly in the code. We have specific numbers in this case, and I think we should pull up the actual code section. there, and let's see if there's a way to.
You don't have it?
I got it. Oh.
Yeah. Oh. We're locked in. Come on over.
Zoom
Yep.
to,
Fit with.
does it fit with? Yeah, so that's, and then I think I can do this a little bit. So, in this particular case, so that's P 3053. What applies to us is the 1%, because we have a diameter of more than 3 inches. And it says that the drainage piping shall be installed in uniform alignment at uniform slopes of not less than 1/8 unit vertical and 12 units horizontal, 1% slope, 4 diameters of 3 inches, 76 millimeters or more. The video, and I don't want to play the video again if everyone's seen it. The video in this case,
Yes.
okay?
Has everybody seen it? Okay.
Okay, so, and the E-Track notes on the actual inspection mention nothing about any calculations. We've asked the city, we FOIA'd this, there's none of that. And the truth is, they didn't do, they eyeballed it, okay? What is really perplexing to me is how, on the city's position is, we can take this and we can say, this is what we think the true intent of the code is, and we're gonna eyeball it, and we think you're in violation. But I can't come here to you and say, there's other parts that show the intent, because they're not relevant, I've been told. And there's no evidence that 1% was made. That's like a cop proving that you were going 5 miles over without an actual radar gun and saying, my eyes said you were going 5 miles over. And frankly, the officer might be right. But if you're gonna hold us to the strict application of this, the city hasn't provided any kind of evidence that there's a slope violation. That's, you know, I'm not gonna argue, I will answer questions, but that's what's really troubling to me. And I'm not the expert in the plumbing field whatsoever, or any of these technical fields. But we're being told the rules are X, but not really. They're actually a little different. There's a changing ball or a changing court for Mr. Wood, and I don't think this is gonna stop. And the only resolution is for Mr. Wood to not do work in the city of Ann Arbor. I don't think that's what our city stands for, but you know, this, I'm not giving my entire presentation, but I get where this is going. I think that, you know, the record should reflect that we think SOP 501 is pretty clearly applicable here. Mr. Hart provided a chronological argument. Well, the problem with that is that where they applied SOP 501 to Trinity, or that we know of, they might have applied it somewhere else, that predated, or the SOP predated, sorry, the SOP postdated the actual installation of the work. But it doesn't matter in that case. For some reason, it matters in this case. Are there any questions
Okay,
that I can address?
then we'll have the board come up with any questions
Okay.
that they have of you.
Yeah, sorry, I'm unfamiliar with the process.
Somebody want to start? Have any questions?
Do you have evidence of how, in other words, when you looked at the video, at the one spot you could see water sitting in the
Yes.
pipe. Do we have evidence of how deep that water is?
No evidence, but if there's water sitting between A and B, and there's a regulation of the slope requirement.
I understand, yeah, no, I
From one
understand.
end to
There's
the other.
obviously not, it's flat. I'm just sort of curious if there's a sense of how much that is. I agree with you, but is it, you know, just a thin film? Is it just a slightly flattened area? Is it a big dip there? Do we have any way of, we can't tell that, can
Is
we?
there any evidence of what's going on there?
I would go off, when you're watching the video, at some different portions, you can see from the camera that the pipe's half full of water. So that'd
Okay.
be an indication that
Yeah, that
there's
would be
2
an
inches of
indication.
water sitting in the pipe.
I would say quarters, and I wouldn't say more than half, didn't look more than half to me. Looked like it was maybe, bottom quarter, bottom third of the pipe.
Yeah.
Yeah.
It was definitely up in half.
So we don't have a uniform slope from end to end, from point A to point B, because water collects at some point. We don't, so you're not meeting the code requirement of a uniform slope.
So, but it doesn't, the other cases don't matter, right? That's the,
That's right.
They'd have to all
The
go
other
through the same
cases don't
process,
matter.
Ideally, yeah.
the other part of it is, remember that we're installing in line that it already exists, that already has a certain slope that has been approved before. So what we're saying right now is that the city can go and violate all these lines who haven't been updated, that are in disrepair under this analysis here.
This
you
is
can do
a
that.
line that is in disrepair. That's why a liner is being put in place,
Right?
correct?
Mhm.
So the liner follows the disrepaired area. If there's a disrepair that is not collecting water from point A to point B, it can be still lined, but you can't have a liner put in and the liner follows a non-uniform slope.
But that's what's been done in every single one of these cases. They don't go in and change the slope. They fill it in. Unless you do a completely new line, open trench, that's what's done by definition. It's rehabilitation. When I spoke to Mr. Craig Strong about this, he said, you're not making it worse, you're improving it. So my point is, under this analysis, the city can take the position that every house who hasn't decided yet to get a liner replacement or their line is in violation of the code, right? Under your analysis. And I'm just having so much trouble with this because we're trying to have uniform application of the law, is to me, and it does not seem, it's not on my dime, it's on his dime, but he's trying to do business, he's trying to follow the rules, and the rules aren't the same, and you're telling me that it's okay in one.
No, I'm not telling you.
Well,
In this case, it is not okay because you have a non-uniform slope from point A to point B.
But I can
You're not
show
following
you
the
so
code
many cases
requirement.
where that is also very clear. And the city took the position that it's okay for X reasons.
Is there evidence that the city saw water in that? Or was the disrepair different, a different type of disrepair?
Well-
That they still have a uniform slope?
I have the evidence, you don't wanna see it. I'm happy to show you one of the videos. If you let me show you one video of a trenchless approval from 2015, you will see exactly what I'm talking about. And that's my problem with this. And I won't show it to you if you don't want me to show it to you, but it's there. And these are just a few videos that we selected from manual review of eTrack-It, because sometimes the videos are attached, most of the time they aren't, to the approval. But it's, you don't want me to show you the video, should
Well-
we confirm that? Because you're talking about uniform slope, and these other ones are exactly what Mr. Winters is saying is unacceptable in this case, is exactly what these videos show.
I appreciate your frustration, because, believe me, we go through this all the time on plenty of projects we work on. The variance at hand is about this particular building and this particular inspection. It's not looking to revisit things that have happened in the past, and I don't think you want to do that. The question, one of the questions I have is this standard of procedure. Why was it developed or issued in the first place? if it's irrelevant, and if the city can't change the code because it's the state mandate, why was it developed in the first place?
I probably can't fully answer that. I know that since I've taken on the position here, we have the standard of using the code, not the SOP. The SOP is in conflict with the code, while the intent is to have a certain slope in there. And because this is a trenchless type of installation, there's no way, unless we come up with some type of device that'll go through and measure it. But the intent is that it should be draining and not ponding or pooling.
Okay, so, again, I wouldn't want to see you guys come back for every installation that you've done previously under, let's say, the SOP. And I don't think they want you to come back, or they want to come back and revisit that. It's water, so-called water under the bridge, as it were, or under the sewer. But, again, to my mind, this is about a particular standard that was in effect when this particular project permit was pulled, and that's the standard to gauge by. The other thing is, if the inspector saw a pipe and felt that the slope wasn't adequate enough, the burden of proof is not on him, it's on the contractor. For the same reason that when these sorts of things happen on an architectural level, the burden of proof to challenge the code or explain a position on a code falls to the architect. It doesn't fall, the inspector can explain his reasoning or his interpretation of the code, but if it's going to be challenged, it's going to be challenged by us.
That's what I'm doing here today, explaining to you why we are challenging and how we're challenging.
No, well, what I'm saying is, if there's proper fall from point A to point B, to me, it seems that the contractor should be able to demonstrate that he's got that elevation change and meets the percentage slope that's required. Now, as far as why there's a belly in the pipe and it's accumulating some water, there may be some element of reasonableness that's involved there as far as if I'm meeting the proper slope, but there happens to be an existing condition where there's an irregularity, but the pipe is still draining properly, that seems to me that that's something that could be worked out between you guys and the city. But from the point of view of the variance, again, to me, the code that's in effect is the 3005.3.
Can I clarify that we're not asking for a variance? I know that the city
Well, you're
staff
asking for an
report-
interpretation
Yeah, the
of
city
the
cites
city's
the-
denial, right.
The code, or the construction statute. That's not what we're asking for. Another section, R10411, alternative materials, design, and methods of construction equipment. I'm not even gonna read it. Another example of why the city has discretion, and they use the discretion in the favor of the other contractors and not Mr. Wood. And it's so absolutely clear to me that that is what's going on. And I've been told that we don't know what the SOP origination, the basis was for it. Why don't we hear from Mr. Strong? Mr. Strong was in charge. The code says that the city can create policies and interpretations, and that's what they did. And I think that, hold on one second, let me make sure that, I want to remind everyone why we're here. We're not here on principle, okay? Mr. Wood and I are not here because we just want to win. He has spent so far $30,000 on legal fees because we've been fined in 9 cases, now 8. That case is pending, stayed by Judge Valvo, while we deal with the matter here. We chose one of the 8 cases to appeal because it costs $250 per case just to bring it here. And it doesn't make any sense. We wanted to show you one of the samples, and we chose the one we thought was in the worst condition. And frankly, I don't know what to say other than the rules just seem to be, they're hard to follow, you know, for anyone to be able to do any kind of business with the same process. It seems like there's a little bit of personal animosity. I'm not saying from the board, but certainly that we can't get this issue resolved. Trust me, we want to get it resolved, but we don't want to go and dig up 8 different houses, customers who are happy, and say, wait a minute, the city of Ann Arbor says there's a problem. So I need to dig up your yard. I know we chose trenchless, but we need to dig up your yard and go fix this quote end quote problem. So if you have more questions, I'm happy to address.
I have more comment and one more question for you, or I can present to the board, is that there is another section of the code that addresses existing buildings in Appendix J.
Yes.
So why can't we apply Appendix J, it applies to plumbing code, dealing with repair to existing buildings, is exactly what this is.
Can I know that's a question for them, not for me.
I mean, it's,
But Mr. Strong, this is what Mr. Strong suggested to me. He said, you need to propose Appendix J. Now, at that point, this was just about a month, 3 months ago, August, we've kind of moved the wheel. We intend to appeal whatever, if we get an adverse ruling here to the state, more money, we don't want to do that. But that is an issue that I didn't have time to really develop, but Appendix J, and it would be good to see what the city's position on that is.
I mean, we use Appendix J for a lot of other structural concerns, stairs, existing conditions, so it's in the same ballpark as plumbing with existing conditions, where we're repairing it. It's clearly a repair.
Is there other areas that, are there other means of repairing this sewer line that from A to B has a dip in it?
I'm pretty sure if you can find out, well, the camera shows the distance, right? There's a number. So you take the camera from the house, and it says at 55 feet. This particular case, we're talking about 56 feet to 70 feet or 80 feet.
81.
So the repair would be to go and open up the
30
yard.
feet, yeah.
I suspect, and we're not there yet, there's gonna be a few angry homeowners because the people like Dorothy Brooks are gonna say, what, there's nothing wrong. So that's a different issue, but that's why repair is expensive for us, or else we would have done this.
And these are out in the street, because it goes from the manhole back in, so the last piece of the pipe is the part that's underneath the street, that's the part that's
Yes,
got
it
the
would
belly.
require additional, the cost is astronomical from our perspective, and that's why we're even here. There's no, I don't want to get into a tit for tat with the city. It's just the money, $100,000+, or try to take these appeals.
The actual repair, when a bid is given to the homeowner by the contractor, does he know what the condition is of that pipe?
I think the video.
When you
was
say-
shown.
Yeah, the video, oh, there's a pre-video.
Yep.
So that video is shown,
Before, okay.
yes. And,
So
and
why doesn't he say, the city, shouldn't he say that my repair is going to be digging up this section, repairing the pipe, putting the liner in for the whole length of the.
going forward, you're saying?
No, not going forward now. In his bid, he should not give a bid.
Well, what he could say is, if you go to Roto-Rooter, there's gonna be no issue. He could say that. Because all the other cases that you won't let me show you are Roto-Rooter, and they're the same exact issues. But I wanna understand this. You're saying to the existing problem homes, to go to them and say, the city has told me we're in violation of this slope issue.
No, not for previous,
Going forward is what
So
I'm.
for this house, we videoed ahead of time, we saw the belly and we saw the puddling, and we still chose to line it, was a candidate for
Oh,
lining it.
because, that's an easy answer.
Yeah.
Because he's done it so many years without issue, including in this city. And Mr. Dan Ratliff was okay with it. And the videos, again, that I really want to show you, one of them at least makes it clear that the policy changed after Mr. Mr. Strong left. So it's really expensive for us, ladies and gentlemen, and that's why, and this is from now 5 years ago in this particular case. No, I'm doing bad math. 4 years ago from the installation.
Does the board
So,
have any other
yeah,
comments?
So hypothetically, to the city, somebody comes in today to them and says, my sewer's failed, I need it relined, okay? And he's got a state approval, it's a certificate of acceptability, he goes ahead and puts it in. What's the standard that applies to the installation?
Ryan, can you share the process and what
Well,
would be
that
involved?
would be, it would still be under the 3005.3.
So the code doesn't recognize that ASTM F, whatever it is, 1216 standard for cured-in-place piping?
That's correct, that standard's not in our code book.
It's not in the code book. So, because I looked in the 2009 and I didn't see it referenced in the reference standard. So that hasn't been applied, it hasn't been accepted either.
Correct.
That's why the state's involved with the product and how they go through a review process, and the state either approves or denies.
So, so if the state issues a certificate of acceptability that the product is okay to use in the state, why wouldn't it follow that they would also have adopted or accepted a standard for testing or acceptability of installation?
That's all can be covered under the existing codes.
In past, if you look to some of the other adoptions by the state or allowances for particular materials that haven't been approved in here, if you go to Permaliner, the acceptability, it states various conditions, and one of them is the rules and code requirements. When LMK was adopted, they didn't put anything in there, so neither did they did not accept the standard as opposed to the code, but we always refer to the code. It's gonna usually take the precedent of whichever is stricter, and that's even in the statement in the codes, in the code book itself.
So I can understand F-121609 has been approved by the city. That's the Permaliner that Roto-Rooter uses and was mentioned in that SOP is F-121609. And then it has manufacturer specifications. Our LMK that has been approved by the state is based on the same 121609. I don't understand why it's acceptable for Roto-Rooter's Permaliner, but not for ours. It's mind-boggling. I don't understand. Like, it works here, but it doesn't work here.
I don't think it's I think it's not the material, it's how it's installed in this particular line.
Yeah, that's F-1216. That's the
You know,
installation.
Going back to the code 3005.3.
You're saying, the code doesn't specifically replace, the code does, you're right, it does not say asterisk, but for CIPP or trenchless processes, 1216.9 applies. It doesn't say that.
Right.
But the code also says that not every single reference standard, not every potential code, ATSM, F, whatever, are going to be listed. And there are code sections in the code where the city can use them to apply, and specifically this alternative materials one. I mean, it's absolutely clear that they can make a determination and say, if we think it meets the general idea of protecting the human health, that it's okay. They're allowed to do that, and they've done it at some point. They're choosing not to do it in this case, which is similar to the argument that Mr. Darling brought up on this Appendix J. There's many ways, folks, for this to be done. And I don't know what to do with the other 7 cases, because it's not just about paying a $1,000 fine that we're dealing with at 15th District. It's about going to the homeowner and saying, they can continue fining us over and over again. if we don't go and dig up. But how are we supposed to tell the homeowners, we dig up here, but they don't have to dig up over there? And in the face of the code that clearly gives them the leeway, the discretion to approve. I want a last thing. This is Waltham. This is the case. I hope that everyone, I think everyone had an opportunity to look at this, but we were talking about practicality, the kind of the slope. Here we go. The general slope. What I'd like to, so this is coming out, and it'll show at 80 feet. You'll see the water there. Okay. Oh, it goes back to the 81. And there, for some reason, there it sits here. This the video it just sits there, and they don't move the. There we go. $78 feet.
See, that was halfway.
Okay, and then you go up to it. You don't see any water here. Okay, and what you can tell here,
There's the water.
okay? You do not want to see the other videos, but I don't know how to explain this to my client, that it's not acceptable here. But then, after we get past 56 feet, okay, we're at 62, it stops.
And that's a quarter maybe there, what is that?
That's a quarter, about
Yeah.
a quarter there, quarter of the diameter.
Okay, we get to 56 and it sort of turns. To me, and I'm not the expert, this is going now uphill. We're backing up uphill. So when we're looking at the
Back to
whole
the house.
trajectory of the whole 80 feet, this to me, and there's clearly no water here. Well, there's a little teeny dribble there. Okay,
Might be a
to
picture
me,
one,
this is
yeah.
going uphill. Okay, and again, it's what the line that was existing there before, the groove or the contours that it had. So it seems to me that the best solution for my client is to not do these, because you can't go in there and change the configuration without an open trench. And that's obviously not the city's policy that you can't do CIPP or trenchless jobs. This here, to me, this seems like it's going downhill. And I don't know why it keeps stopping, but they pull it back up. We're at 23 feet from the house, or from the clean out, I should say. This is a 4-inch liner. No issues here. It seems to be there's a slope down.
So they potentially could do a partial replacement, the first 30 feet, they dig down 30 feet in one hole, replace the other piece.
30
and
feet,
leave the other
folks.
piece.
30 feet, 30 feet.
That'll be at the sidewalk or where some other,
30 feet at 8 different homes.
yeah.
3 feet, and then it's pulling out to the clean out here, 1 feet.
I mean, there doesn't seem to appear to be a health concern here because you're not doing anything that's been in place for 4 years. It doesn't seem to be a health issue. It's a life safety thing.
But it could be.
It's been there for 4 years. Have anybody gotten sick? Anybody been harmed? Has any employees been
So
backups?
what could happen here is a sewer backup in our basement, right? And I had a lot, there's no need for an anecdote, but that's the issue. We have a 10-year warranty. We're willing to extend it however long Mr. Wood lives, or his company's in business, because that's how confident we are about these sewer backups. There's one case where he did go into the client at the beginning, Gloucester, which has now been resolved because it has been redone, where Mr. Wood said to the homeowner, this one's pushing it. This one's pushing it. I can tell you it's too much, too bad. But the homeowner said, I have this beautiful garden. Please, let's try. They tried it. It was violated, meaning it was not acceptable because there were backups. That has been replaced. The homeowner knew from the very beginning that this was a very distinct possibility. Mr. Wood's not in the business of going in and putting these liners and then disappearing and having people's sewers back up. So I wish there was a resolution. I'm open to it. Please, if there's some way to do it, but I don't think there's really a safety concern here. And, yeah.
All right, board have any other questions or comments?
So there's 7 other installations out there.
Yes.
Are you guys going to go back and visit those?
They've been violated, I believe, and,
So they are in violation? Under the same 3005?
yes.
Same problem. Each one's, they're all different. I mean, it's all just different variations.
Yeah, no two lines are gonna be the same, but it's the
Well, no, I
same
just
idea
wondered
with
if there
water.
was consistent water problems where you've got billing, because that would seem to be the most obvious thing.
Yeah,
to
not
spot
in all of
inspection.
them.
Not in all of them.
Okay, any other comments or questions? Board?
If a sewer line fails and a replacement has to be made, it has to be done with acceptable materials and following, the installation has to follow standards, correct? I mean, you can't, if this was dug up and there was a belly in the existing pipe, you couldn't lay pipe along that. That new pipe would have to be of uniform alignment and the proper pitch, correct?
Correct.
So it occurs to me that while this system seems to have some benefits, it can't be used in every situation.
May not be appropriate everywhere.
And that's, I think that's the contractor's responsibility to know where it can and can't work. Uniform, well, here's what I know about drain piping. It should be smooth and straight and pitched, not so much that the water runs so fast that it won't take solids away, or not so little that they don't move. And anytime you have bellying and stuff like that, eventually solids are gonna collect there and solidify, and you're gonna have problems. Maybe not in this 4 years, but eventually you're gonna have problems depending upon the usage. So, I don't see a remedy for us here. It's not something I would accept.
Okay, anything further?
I mean, I guess I just have to ask one more time, as a practical matter. It's okay to use this system, but the ASTM standard just doesn't apply to its use or to the inspection process here.
Correct.
What does the SEM standard cover? Where's that inspection process and what is that?
Well, what it does is it allows for humps and bellies
Yeah.
as long as the slope, the
Oh, yeah.
required slope of let's just say 1% from point A to point B is met.
Over a longer distance.
Right.
Yeah.
I mean, that's a synthesis
We could make that part of the variance, that we could assume that it's applicable to the standard, because since it hasn't been adopted.
We are not we are not asked to provide a variance to this, correct? We're not asked to provide a variance and say,
That's what their papers say. That's exactly what their papers say. That
It's either
that we're
this or
asking
this.
for a variance. But I'll be honest with you, I mean, I'll read it to you, it's at page,
You know, yeah.
I mean, there are provisions in the code appendix J, there's a provision there to accommodate that, President. Talking about it, that says that they're asking for what?
yeah, so
They're
go to
asking for
page
the
4,
inspection
or
to be
page 8 of the
undeniable.
entire package. At the bottom. The city writes, one of the requirements and conditions of Public Act 125/1515, the specific condition justifying the variance shall neither so general nor recurrent in nature as to make an amendment of the code with respect to the condition reasonably practical or desirable. And then they cited earlier.
This is from her.
So if I might comment on that.
Yes.
If you go to page 5, there's a standards for approval. It actually comes out of the Public Act, and there's reasons, it's how it was written. And there's reasons that allow you to give,
Oh, there it is.
yeah,
Page
there
5.
there is reasons for that. However, in the variance, you can't approve it unless it meets those guidelines.
Wait, we can approve it. You're saying-
Any type of exception that's gonna be allowed has to meet the standards for approval by Public Act 230, section 125.1515.
On page 5, are we looking, it's page 9 of the packet, and what he's
Right.
saying is, after a
Page 9,
public
yes.
hearing, a Board of Appeals may grant a specific variance to a substantive requirement of the code if the literal application of the substantive requirement would result in exceptional practical difficulty to the applicant, and if both of the following requirements are satisfied. The performance of the item or part of the building structure with respect to which the variance is granted shall be adequate for its intended use and shall not be substantially deviate from performance required by the code. We have 4-year track record in this particular case of there being the sewer doing its job. And with respect to B, the specific condition justifying the variance shall neither be so general nor recurrent in nature as to make an amendment of the code with respect to the condition. I think you're not, I don't think you're allowed to tell him, don't worry about this forever. We're asking about the 8 in particular. So if a variance is appropriate with respect to the 8 only, so we can put this behind us and going forward, he simply needs to get approval before he even goes and puts some line in. That's what he needs to do. But we're not worried about the future. We're not gonna come in here and do a bunch of more installations and not pay attention to exactly what Mr. Ryan Miller and Mr. Dempsey wants. But I think the variance could be appropriate in this case because it does provide an exceptional and practical difficulty to us to have to, if we're looking at it, P3053, to comply with that 1% at this point. So there's several ways to skin this cat, I guess, to get a resolution. It's a matter of, we do need you to have a little discretion in our favor.
I have one more question on this, is that in 2004, the permit was, they turned the video in and the permit was closed?
2014, you're saying?
Yeah.
No,
They
there was
accepted that
just
video? They just never closed it?
nothing.
No, they didn't do anything with it, it stayed
Yes.
open?
And I will be the first one to say, you
Yeah.
can't do that, Mr. Wood. You need to go and follow up immediately. But there was a system they had going.
And that's why the city went back 4 years later to inspect it?
Yeah, the city went back at some point after Mr. Miller came to the city, or Mr. Dempsey took over as building official, I think. And I don't know what the origins of it, we don't need to point fingers, et cetera, but that's when it was kind of, wait, you have a product that doesn't comply, or a product that is not approved, and we got it approved. And 20 days later, wait, you have another problem. You got 8 violations, 9 violations of P 3005. So I feel like I'm wasting your time at this point, but
We are not concerned about the other 7 or 8. We're concerned
I
about this
understand.
one.
But what you're
Mr.
doing.
Dempsey has a comment.
So I might add to what we were just talking about a moment ago is, I don't believe he's asking for a variance, he's asking for an interpretation. Have we interpreted the code incorrectly? I think the intent of the code is, in staff's opinion, is that it doesn't meet code because there's not drainage in various parts. The act refers to it as such, and it can't be so reoccurrent in nature that other issues are gonna come up and have to be approved because of this type of exception. Even though they may be a little different, it's still holding water, and the intent of the code is there, and I believe that it should be denied. His request in the appeal was to, let me just get to that. To find that the SOP applies to this permit, that there is no violation in the code, MPC 3005.3, and they're looking for, they're basing it all on the SOP, and that the code section that we've used is incorrect.
There's no doubt that I agree with you that we didn't ask for a variance. The city is saying Or if you're gonna approve this, it has to meet the variance statute.
Well,
Why else would they bring that
yeah,
up?
the only,
They're the ones that brought it up.
the only problem with that is that with those other 8 that are, or 7 or 8 that are currently still hanging out there, we have no idea what condition those installations are in, whether, you know, to grant a blanket variance.
Maybe just this one is when we have an application for it.
Correct. So I have one, let me ask just a purely practical question. However this turns out, do you guys have is there any kind of a practical way to deal with this so that it doesn't drag on and become a burden for both the city and them? I mean, is there any way to work this out if this is denied on a purely practical point of view?
I believe that the code's currently not being met. I know that other installations with CIPP that have been put in place, and maybe I'll defer that to Ryan, there have been times when the situations were very similar, and those spots in the liner have, or those spots in the existing sewer line have been corrected and then lined. However.
Corrected, you mean dug up and re-leveled?
Right. Broken pipe, collapsed pipe, pipe that wasn't correct. So I think that is a possibility. If they had any other solutions, we would always entertain looking at those if they want to pass them by us. But I think right now, under this particular case, I think that we have water that's pooling or ponding. It's looks quite excessive to me. And I think that's where I'm at with that, and I think that's what our plumbing inspector has found.
I'm taking that as a no.
So with that, the only other thing that I would say, also the code section, if you might go, if you go to the actual code book itself, and it was stated in the introduction, if you want to look to that, it talks about the intent of the MRC rules governing construction is one way for an appeal. It talks about the provisions of the MRC that do not apply, or an equal or better form of construction is proposed. So I don't believe it's meeting the Public Act.
So could we consider 2 motions, one that as with the request and one for a variance under section Appendix J?
I don't know if Appendix J applies.
It's an existing building and it's repair.
It is a new pipe being installed, though.
It's repair. It's definitely a repair project, right?
We can, what I wanted to avoid was, there's 7 other shots at, or bites at the apple. I don't want to come here over and over again and say we have a new argument, but from a practical
Well,
standpoint.
that's my question about a practical point of view.
Yeah, so there's a way, I'm not asking for a variance on all 7. If the board wants to look, or all 8 today, because we agree, we're here on one case. We did that because we don't want to pay $2,000 in filing fees. If the board needs to see every single one of the cases, that's fine with me. And also, we would be willing to be open to Mr. Wood no longer doing work in the city of Ann Arbor. If that's something that they need, as much as that is, to me, it's unfair, that's something we'd be willing to do.
See, I have to tell you, I don't agree with that. I think the way forward on this is that if somebody has a sewer issue and, you know, and one option is for relining the pipe, that it's a function of due diligence on his part and understanding and establishing in a written way the rules of engagement with the city at the very beginning.
That's what was done at certain points, but it doesn't apply in this case for some reason. Not to beat the dead horse, but that was Mr. Strong, and his policy clearly says, here's going to be our policy. And if that's no longer the policy, that's fine.
No, but it's one thing to have the policy internal, but it's another thing to have the policy shared with whoever is going to be pulling the permit and doing the work. What I'm saying is, going forward, if you can establish what the game rule, the rules of the play are as far as doing the work with that particular system, that doesn't preclude him from doing work here in the city. It just means an extra couple of steps in order to make sure that everybody's on the same page and there are no surprises at the end of the game, at the end of the end of the project. When
That would be
nobody's
our
really.
preference.
Pardon me?
But that would be certainly our preference to have what the rules are, but we're willing
But-
to waive that to avoid $100,000 of going back to customers. And that's our practical problem, is what do we do about these other ones that we think are similar to other cases that have been approved? We already covered that. I'm happy to talk to them about a practical solution, but our conversations have not been really there at this point. It's been from one case to another, and now, it sounds like they're saying, you only appealed, you didn't ask for a variance. Well, they brought it up. I could play the game and say, fine, we lose this one, we're gonna do a variance. It doesn't on another case, and then I don't wanna do that. It's really expensive and time consuming. We've been here and we've wasted an hour and a half of your time or more.
You haven't wasted our time.
I feel bad.
This is what we do. So,
Okay,
I
well,
mean, we're
I
used
just-
to this.
I
believe
feel
me.
like, I feel strongly about this, but I also don't wanna, overdo it, but I'm open to whatever the solution. Variance, Appendix J, I also think 104.2 can do it. There's many ways to do it, so I'm gonna go sit down unless you have questions.
All right, thank you. Thank you very much. I'm asking
I'm just worried about
the city,
making the motion.
do we have,
Having my disclosure at the beginning, but.
We can only
support your opinion,
ask for not for a variance of this particular case, but of the interpretation, we're to rule on the interpretation of the code.
You said there was something.
by
We've
the city.
interpreted the code incorrectly, yes.
I went by
There
the
are three things in the
abbreviated
code section.
section, so.
Thank you.
This part here.
Oh, yeah, that was the SOP, yeah. I was looking at this.
Bob?
Yep.
So we are to rule on the interpretation
Yeah.
that the city has, whether that's correct or not. Okay. Would you like to go ahead with the motion?
Yep.
The board doesn't have any other comments or questions?
But the only observation I made is that much has been made of the standard operating procedure Mr. Strong made, but this work was done prior to their discovery of it, so I don't see how that plays in. Just my observation here.
Thank you. All right, Bob.
All right.
Yes, sir.
I move that in case BBA 18-006, the appeal of the building official's decision that the work performed by Reuter MD at 1625 Waltham did not pass final inspection is denied, and the Building Board of Appeals affirms the building official's decision for the reasons that, one, the true intent of the 2009 Michigan Residential Code and P3005.3 governing the construction at 1625 Waltham have been correctly interpreted by the building official, and two, the provision of 2009 Michigan Residential Code P3005.3 applied to the construction at 1625 Waltham.
Thank you. So is there any further discussion on the motion?
I'll
Is
second.
there a second for motion? Bob Hart did the motion. Okay. And we've got a motion, we've got a second. All those in favor?
Aye.
Opposed? Motion as such is passed. So the ruling is that the city has interpreted the code properly.
I understand.
Okay?
That's very clear.
You want to make a second motion?
Yeah. Do you want to, go ahead.
be probably the other section, probably. It would make, we could,
Wait a second, hold on,
Wait,
hold on,
wait,
wait.
Can we
You better
do-
check on that
yeah.
first.
So can we offer a variance based on Appendix J?
I would have to look at that. I really don't know, but I don't, from what I've seen, it's not a repair, but I'm not the expert on that. And what I would say is that the board has made a decision on the appeal, which was not a request for a variance.
We can go past what they request. Sometimes we offer other options, and that would resolve this particular case, potentially, depending on what the outcome is.
You're asking a legal question that I have not researched.
I mean, in the past, you've done that.
I have not
Yeah.
researched it, so
Yeah.
legally, I cannot
Yeah.
provide an opinion, nor would I do so in public, because it is you do have an attorney-client privilege. I don't know if Mr. Dempsey has anything to say about that.
I would have to review it further, to be honest with you.
Okay.
I'd have to review anything further
Oh.
because it's never been proposed to us. We've come up with this interpretation that code was required. And compare it with underground piping, one consideration that it's considered similar to a new pipe as opposed to a structure or an existing building.
I mean, the Appendix J does reference plumbing, right there in the Appendix J, it does reference plumbing. And this would be considered a repair, it's a liner, it's not the structure by itself.
We've had this difference in interpretation, I think, on the definition of this liner. However, it's something I can investigate further. I have no problem with that.
Just procedurally, can I ask?
Yes, sir.
So the city's attorney who's opposing our client is your attorney? And you have to ask the city attorney's permission for a certain procedure? Is that what's going on right now?
Yes.
But you are an
The city
independent.
attorney is the board's attorney, and the city attorney does not take a position for or against. The city attorney advises, and then it is for the client to decide, just as it is with you advising
Sure.
your client.
I understand that part, but I thought there was an independent nature of the board.
There is, but.
I'm not
this-
trying
this
to
was-
be
no, no, this was- this
ridiculous
was-
here, I'm just.
No, no, that's okay. This was, the question, it was a procedural question. And, you know, we're not allowed to run amok, so we have to ask every now and then if it's okay to do something, which apparently it's not.
It's unclear. They
It's
can't
unclear
answer
at
it.
this point,
Yeah.
right? So,
But I thought that the question was about the merits. Does Appendix J apply? You're not asking the city for that opinion.
no.
If we were offered, if we could offer an additional motion
Okay,
besides just.
so,
the inter-
so maybe the solution, well, what is the solution? What are we?
Solution might be for them to come back
Yeah,
and cite Appendix J.
yeah. I mean, we're already here, we already heard the whole thing. The question is, could we do it
And
now?
they themselves say, we're seeking a variance. That's what their papers say. Their own papers are saying, we seek a variance. I know I didn't put that in my appeal, I understand that, but for some reason, their papers say, the standard you need to apply today is that there's a variance sought.
If I may speak,
Yes, ma'am.
I want your permission first. I generally leave it to the experts to talk about the plumbing and the pipes and all of that. But in this case, the citation, just putting in that a variance, that the code, or excuse me, that the state law has a provision for variances, doesn't mean that that's what the city understands or the building official understands is what is being asked for. And representing my client, which is also Mr. Dempsey, he has informed you that this is not an appropriate case. Now, that is for you to decide, but the only reason that I'm jumping in here is because Mr. Wood does have the benefit, maybe you, of a representation. And when there's a discussion of the law, I think it's appropriate for the city attorney to weigh in but it's the board's decision. You are the judge,
Fine.
just like when we argue in court.
Thank you.
One thing I want to read with respect to the variance, in their conclusion, it says, while there are situations that may allow a permissible variance, this is not one. Public Act 125-1515, Section 15 has 2 conditions, and it goes to talk about, this is their conclusion, about when a variance is appropriate. So as I interpret Ms. Larkham, it's your call whether or not a variance is appropriate under whatever code section that you want. If you're not comfortable with that, I'm happy to come back next month, so that we don't have to file yet another appeal, if that's what the board wants to do, and we can give you additional information on whether a variance is appropriate or not.
Let's not go ahead with this at this time, but advise the appellants and the city that there's the possibility of this possibly passing the board under Appendix J, and it's up to them to request that it be applied that way.
There's only one, the way I see it, there's only one danger with that, is that this was all focused on one situation. There are 7 others out there that I wouldn't feel comfortable applying Appendix J to without knowing more about it. So that's a potential pitfall, which is why I'd really like to see you guys settle this in a very practical way.
You're not the only one. Can we bring, I mean, we can provide all those cases. That my issue was, and I'm sure we'll just eat the $2,000 to formally, but I asked the city if they'd take the position that we can bring all of them under one filing fee, because they're all the same sewer line with a little, whatever their, their claim is. Is the board willing to entertain those at the, I'm not sure if I'm available at this next hearing, I think I am, but when you can see all the videos for yourself. And we'll make a formal request for a variance under Appendix J or something.
I don't think we can rule without seeing the conditions, seeing and talking about the actual
Each is an individual
conditions of
case.
the individual
Yeah, I will
case.
we'll provide the videos before the next hearing, and we'll do it there. And if you want us to pay the filing fee, we'll just deal with it. And we'll pay the filing fee on all the other 7, and we basically have all of them at the same time. Though I don't think there's a need to pay $1,800 to bring all 7 additional videos, but I don't know what the rules are on that.
Just for clarification, because there are legal procedures. The board has ruled in this appeal. There is that ruling. So if I'm hearing correctly, we're now talking about the applicant coming back with a new request. And, but then we're getting a little farther on, I mean, I don't think there's anything to stop the applicant from making another request. But, like he's talking about, but we're going farther than that, and the practice has always been that each case is treated individually, and the reason for the fee, the city doesn't make money on these. I can guarantee you the amount of time that it takes to prepare is quite a bit, and I understand it's not great for the applicant either. It's unfortunately the system, for better or worse.
Okay, so I have one other question here, procedurally speaking. So we've made a ruling on this particular case. The city's given an indication of how it plans, of how it's interpreted the past 7 situations, right, the P3005. So isn't the next step going to the State Board of Appeals?
For the, yes,
I mean,
For one.
this is,
for this one.
This is a state-approved system. It's the state built, it's the state code, so in
Yes.
order, right, to put,
He will have up to 10 business days to file with the state of Michigan. There's a form in that packet that you've seen.
Yeah.
If we get the sign-offs, we can provide that to Mr. Wood, and he can appeal this with the state of Michigan.
We are getting back off the practicality thing. With all due respect, what the city wants us to do is to take each one of these through you, get it denied, and go to the state. That's impractical for us. But we also can't pay $150,000 or whatever the cost will be, I have no idea, to go and fix these. So can I just have a directive, a very clear directive of, the board seemed to be inclined to consider a variance under Appendix J. And so it suggests that maybe that's worth bringing before the board.
no, actually, I don't want to speak for the board, but I wouldn't say that we're inclined. It was a question that came up. But it seems to be a bigger question on this, procedurally on the city side, whether that's, a valid consideration or not.
So, the applicant came in, he's appealing our decision. Our decision has been that the code that has been mentioned in here, P 3005.3, is applicable, and he's considering it using the wrong code. Whether it's rehabilitation code, SOP, or other situation, we've stated that this is the code that's applicable. The ruling's been made, he has the right now to go to the state board. To come back later, he can, again, we can revisit those, I have no problem with that on these other issues. And we can see if our ruling was incorrect. I don't believe it was. He can appeal those again if he so chooses, if we don't change the outcome, but I will tell you that he has a 10-day right now to go to the state. The state can then rule on it from there.
If he appeals to the state and the state decides that rules in his favor, does that mean the other 7 are immediately rolled into that?
No, because these can't be reoccurring situations that are enough to change the code. It's something that I would have to look at further. That's where I myself, and most likely Mr. Miller will join me at the State of Michigan's Construction Code Commission, if he decides to appeal it there. So,
The reason I ask some of these things, we get these variations where people are coming to the final inspection where a stairway gets turned down. There's too much variation. During those meetings, we were able to come up with a solution, a variance as part of that, and the inspection, because the inspector caught it didn't comply. Same thing here, the inspector comes in and says it doesn't comply, and you're saying that so I see that there are other cases where we deal with that, with other types of parts of the building. Variation in width of the stair, the height of the stair, and particularly in the existing buildings.
But the way I see it, the difference there is that in those cases, what the numerical or the quantitative
You can measure it, yeah.
issues are.
Here it's just
And this is all very subjective. I mean,
yeah.
even if the bellowing or the bellying was acceptable, you still don't know whether the point A to point B slope conforms. I mean, you have nothing to gauge it against.
I mean, you could survey it for the house end and the sewer end, you can get the 2 ends. and you
But
draw
Mr.
the
Hart,
distance.
they
That's
don't do
all
that
you
in
can
any
do.
of them.
What?
Mr. Hart, they don't do that on any of them. That's not
We
part of their,
understand.
Yeah.
right?
We
No, no, I
understand.
know.
So
that.
why
Yeah.
is it okay in some and not in others? That's the part that's impossible for me to go reconcile.
My feeling of that is the contractor's responsibility to see that the existing meets code before he comes in and does some lining.
But that's not what the rules that, they don't require the contractors to do that. They don't, you didn't want, we've already talked about this, so thank you.
All right, thank you very much.
hey, Mr. Winters,
Yes.
can we get that filled out and we can get him a copy of this? So he has this to take with him to the state along with our packet that we
Okay,
provided.
after the meeting is over.
That would be fine.
All right, appeals, actions, and show cause hearing is completed. Anyone have old business? Anyone have any new business? Any reports and communications? Is there any public commentary on this item or any general item with the city and the board? Without that, we will be ready for a motion for adjournment.
I move we adjourn.
Motion and support. All those in favor? Aye. Opposed? Everybody's in agreement. We are adjourned.